COVID-19 and the law. This is the first part of a two-part series where we would first be talking about the national and the international impact of the laws around COVID-19. And in the second part, which would be released soon enough, we would be talking about welfare and governance measures in and around COVID-19, again from an international and a national point of view. So, let's jump right in. Let's first understand the nomenclature of the viruses and species. The virus is called SARS-CoV-2, Severe Acute Respiratory Syndrome Coronavirus 2. This name is based on the genetic structure of the virus to facilitate the development of cure. You will wonder why the virus is named so complex. It's because it serves a technical purpose. The virus has such a long and a complex name because its purpose is to inform medical experts and scientists all across the world about the origin of the virus and the species so that they can immediately begin research towards the discovery of cure. All viruses are named by the International Commission on Taxonomy of Viruses. The ICTV is an organization which is a part of a larger organization called the IUMS, which is the International Union of Microbiological Societies. This is an international organization comprising of research organizations from all across the world which specialize in microbiological research. In fact, the Indian Agricultural Research Institute is a part of the International Union of Microbiological Societies. The IUMS is a part of a larger umbrella organization called the International Science Council. And the International Science Council is comprising of research organizations from all across the world, not only focusing on scientific research, but also focusing on research relating to social sciences. In fact, the Indian Council for Social Science Research is actually a part of the International Science Council. The International Science Council happens to be the umbrella organization under which the IUMS and the ICTV subsequently exist. It is important to note none of these organizations in any way whatsoever are a part of the UN. These are independent international organizations. Now, let's look at the disease. The disease is called COVID-19, where the first two letters CO signify corona. The next two letters VI signify virus. The letter D stands for disease, and the numbers 1 and 9 stand for the year of origin, which is 2019, which is when coronavirus was discovered for the first time. As you would notice, the disease is named rather simply because it serves a simpler purpose to create a mass awareness amongst the people of the world so that they can understand, retain, and communicate better. This is why viruses and diseases are named separately. Viruses are named in a complex way to assist medical professionals to figure out a cure sooner. Diseases are named in a simpler way so that people across the world are better informed. Much like HIV is the virus and AIDS is the disease. Now, the disease is officially named by the World Health Organization, the world's largest intergovernmental organization advancing the cause of public health. Before the WHO decides the name of the disease, it consults two other organizations in the world. The first is the Food and Agricultural Organization, FAO, which is a part of the UN, and the second is the World Organization of Animal Health. Now, the World Organization for Animal Health is not a part of the UN, but is often consulted by organizations such as the WHO and even the WTO because they specialize in animal welfare and veterinary practices. So, after taking both of these organizations into consideration, the WHO moves on with the naming process. And the guidelines for these are mentioned in the International Statistical Classification of Diseases and Related Health Problems. Now, this document is also more commonly called the ICD, the International Classification of Diseases. This document is like a global census of diseases, where all possible diseases known to humanity are listed here. So the WHO conforms to the guidelines, names the disease, and the disease is then listed back into this document. This is how a disease is named. Let us now focus on the role of the WHO. The WHO leads global efforts on creating safer practices and preventing public health disasters all across the world. And to fulfill the same objectives, the WHO came up with something called the International Health Regulations. These were adopted in the year 2005 and enforced in the year 2007. So, what are international health regulations? They very simply are legally binding agreements on all WHO members, including India, which means every member of the WHO is legally bound to implement what is written in the IHR, which is the International Health Regulations. So, countries must make necessary measures, whether it is making a law or setting up dedicated institutions to prepare for international public health risks. This could mean a dedicated law, specialized institutions. This would also mean certain checks on transportation. This would also mean certain basic measures that have been taken to prevent public health risks from happening, so on and so forth. Each of these regulations are binding on all the members, which means there is a question. What happens if a member does not follow these regulations? This leads us to a larger understanding of international documents. No doubt, a lot can't be done if a country does not abide by the international health regulations. However, a lot is still at stake. Most importantly, a country would face a massive loss of life, economy, and property if these basic regulations are not conferred to. Two, the country may also face the threat of sanctions from all across the world by multiple countries. And third, the country would obviously lose reputation on the diplomatic front. So, therefore, it is common sense that following these regulations is actually in the best interest of the countries. Clear? Let's now understand the next component of this. Inside the international health regulations, we also see a term which is called the Public Health Emergency of International Concern, PHEIC. The WHO often declares a PHEIC on the outbreak of certain diseases. Therefore, coronavirus or COVID 19 has been declared a public health emergency of international concern because it is a public health risk to other states through the international spread of disease. And second, it requires a coordinated international response to battle it out, a lot like pandemic. A pandemic is when a disease crosses the national boundaries of a country and moves all across the world. So the word pandemic is officially defined as a public health emergency of international concern in the International Health Regulations, which is a document of the WHO. This is how, from an international point of view, certain practices are put in place, certain organizations are put in place, and certain measures are put in place. Now let's understand the domestic front. To be very clear, COVID 19 is a problem of public health, and a problem of public health also leads to a problem of public order. Let's understand from a legislative point of view, from a legal point of view, how are we placed? The Constitution of India, under Articles 245 and 246, talk about the distribution of powers between the center and the states. While 245 gives you the basis, 246 very clearly defines on what things can the center make law, on what things can the state make law, and on what things can both the center and the state make law. And for this, 246 refers to something called the seventh schedule. In the Constitution, the seventh schedule identifies three lists: the Union list, on which only and only the center can make law; the state list, on which only and only the state governments can make law; and the concurrent list, where both the center as well as the state governments can make law. Now let's understand what's inside these lists. Entry number 1 of the state list talks about public order. Entry number 6 of the state list talks about public health, which means the states should have the first go at it. But hold on a second. We have something called Entry 29. Entry 29 in the concurrent list says the center can make a law on anything to prevent the spreading of infectious diseases from one state to another. This is a classic example of federalism in India with a unitary bias. This means if something is in the concurrent list, both the center and the states can make a law. If the center is making a law on something, the state laws remain redundant. If the center hasn't made a law on something, the states can continue to make a law. And that's the basic essence. So, no doubt, public health and public order are in the state list. But entry 29 of the concurrent list gives the center the power to make law, take certain actions, make certain measures because it is trying to prevent the spreading of infectious diseases from one state to another. This is how the federal structure in India is essentially governed. And this is why the center could actually come up with the national lockdown. And this is why, if the center has a national lockdown, it is implemented across the states. But if the center does not have a national lockdown, then the states are free to have their own state lockdowns because ultimately it is in the concurrent list. Now let's understand this through some real-time legislative provisions. When we hear the word lockdown, we must understand the origin and the implications of the same. The most important law, often not discussed in the right amount of detail, is the National Disaster Management Act of 2005. It is the National Disaster Management Act of 2005 which is the key empowering provision for the lockdown to exist. The National Disaster Management Act creates two organizations at the forefront: the National Disaster Management Authority and the State Disaster Management Authority. Let's focus on the national one first. So, the National Disaster Management Authority, which is created through the National Disaster Management Act, is headed by the Prime Minister. After the National Disaster Management Authority is convinced that COVID is indeed a pandemic as declared by the WHO, the National Disaster Management Authority, headed by the Prime Minister and comprising of several expert members, can take a certain amount of measures. Section 6, Clause 2, Subclause I empower the National Disaster Management Authority to give directions to the center and the states to ensure social distancing. As the WHO says, social distancing is the best current cure to COVID 19. So the powers are originally given in Section 6, Clause 2, Clause I, which means now the National Disaster Management Authority is going to inform the center as well as the states. Now, how does this work? The National Disaster Management Authority is assisted by the National Executive Committee, which works on the advice of the National Disaster Management Authority, which works under the directions and the larger organizational framework of the National Disaster Management Authority, and implements the measures that the National Disaster Management Authority wants them to implement. So, the NDMA directs the center and the states to take certain measures. What measures? These measures are drafted by the National Executive Committee, which is headed by the Home Secretary of the Government of India. You would ask, why the Home Secretary? Because the Act says the Secretary of the Ministry in charge of disaster management will head the National Executive Committee. Now, India does not have a disaster management ministry. What it has is a disaster management division which is under the Ministry of Home Affairs. And the Secretary of Home Affairs is the Home Secretary, who's also the in charge of the disaster management division, which makes him the chairperson of the National Executive Committee. And he has powers under Section 10, Clause 2, Clause L to give specific orders to implement the directions that the National Disaster Management Authority wants to give. So the broad directions come from NDMA and specific directions, which are lockdown orders, come from the Home Secretary. Which is why, if you go through the MHA order, the order is actually signed by the Home Secretary under powers of Section 10, Clause 2, Clause L. And this lockdown includes a series of restrictions, such as travel restrictions, restrictions on movement, restrictions on commercial operations, restrictions to stop all educational institutions, so on and so forth. The word lockdown doesn't exist under any law. This colloquially or commonly is called a lockdown. When you stop people from moving out, when you stop people from attending schools, colleges, and institutions, when you shut basic commercial operations, when you stop transport and other transportation facilities, what you have essentially done is a lockdown. This is what a lockdown means. A lockdown is not a legal term. Similarly, at the state level, the Disaster Management Authority is headed by the Chief Minister, who has powers under Section 18, Clause 2, Clause D to direct the state, his or her state, and the departments for certain actions. Those actions can be specified, can be given exact details through the State Executive Committee, which is headed by the Chief Secretary, who has powers under Section 20, Clause 2, Clause H to give state specific lockdown measures. This reinforces our point of a state list and a concurrent list, which basically means if there is a national lockdown implemented or enforced through the Union Home Secretary through Section 10, Clause 2, Clause L, the states have to comply to this. If there is no national lockdown, the states have the powers to impose their own version of lockdown because this is ultimately in the concurrent list as well as the state list, which means the states have the powers. There is also something called the Disaster Management Authority at the district level, which is headed by the district collector and the elected representative at the district, which is often called the head of the Zilla Parishad. They also have similar powers with respect to disaster management at the state level. So, what do we understand? There is nothing called a lockdown. What you're essentially doing is informing the center and the states through a series of measures. The larger guidelines are issued by NDMA. The technical details to those guidelines are issued by the National Executive Committee, and that is how a lockdown is enforced in the country. Let's now understand how do you implement it. Because at the end of the day, a lockdown is to stop people from moving, to stop people from traveling, to stop people from going to work, to stop people from assembling in public spaces, and all of this is for their own good. Which means if people do this, they must be punished. And that is why there are several laws in place. The first and the most umbrella law is the Indian Penal Code under Section 188, 269, and Section 270. Section 188 is a criminal offense if you disobey the orders of a public servant. 269 and 270 is to either negligently or with an intention to malign affect a public health disorder. Section 144 of the CRPC empowers the district magistrates and executive magistrates, which are also called subdivisional magistrates, to impose sort of a curfew. Like the word lockdown, the word curfew doesn't exist. Under Section 144, the executive magistrates, which are the collectors and the sub-collectors, would essentially release an order stopping movement of people from point A to point B and stopping congregation of people in public spaces. In the same way, you also have the Epidemic Diseases Act of 1897, a colonial law, which empowers the states to take measures to implement certain safety guidelines to prevent the worsening of the public health situation. Similarly, the Disaster Management Act of 2005 in sections 51 to 60 also contain certain penalties where if you disobey the orders, if you violate the terms, if you spread false communication, these are all punishable offenses under the Disaster Management Act. In addition to this, the Essential Commodities Act of 1955 also gets invoked, where the center and the states ensure that the essential supplies pertaining to food and other things are always in motion. So the manufacturing, the logistics, the distribution, and the selling of essential commodities is uninterrupted, so that people are able to at least take care of the basic. And lastly, very recently, the Indian Telegraph Act of 1885, Section 5, Subclause 2, was also invoked, wherein you can essentially monitor the movements of people to ensure that anybody who has been affected or has a history of travel, or there is a good chance that the person may have been under quarantine or has been under isolation and is violating the terms, you can track the person by simply tracking their movements electronically, and this could make a lot of sense. The origin of this is under the Indian Telegraph Act, which empowers the government to access user phone data in the case of public emergency or public safety. Now, except for BSNL and MTNL, all other networks are supporting this, and because of technological reasons. So that CQAS, the COVID-19 Quarantine Alert System, is created, which means if a person was ordered to be home quarantined and the person was breaching the quarantine requirements, was meandering about, then you can check his movements by checking the location through his user phone data. Now, the law clearly states that the data must also be deleted after monitoring, and the power to this comes from the Indian Telegraph Act. So you would ask, so if cell phones did not exist in 1885, how does the government get the power? Section 5, Clause 2 talks about the power of the government to interpret and to monitor user movement in the case of a public health emergency or public safety. This in modern day means tracking user phone data. In fact, on an international level, you would have also heard of Google trying to do the same to provide large-scale movement data available to decision-making institutions for better identification of COVID patients. And that's how it is done. These are broadly the 6 laws that have been used to implement a lockdown. The failure to apply to these laws, to comply with these laws, would obviously relate or would obviously lead to certain penal provisions. And this is law and COVID. It teaches you the role of international organizations. It also teaches you, despite all the criticism that India receives, to the fact that India is a unitary federal structure. In cases like these, the fact that we have a centralized government, the fact that we have a unified government actually makes things far more easy to implement. Unlike, let us say, the case of United States, which is a far more federal nation than India, where the states are struggling, and if the news is to be believed, then there have been several biddings done by states to procure equipment. This does not happen in India. At the same time, it's also a brilliant case study for cooperative federalism, as even if the center wants to relax lockdown, a few severely affected states, such as Punjab, are ready to extend their lockdown after a cooperative conference between the Prime Minister and the Chief Minister. At the same time, this is also a brilliant explanation of combination of old laws and the new. From the Indian Penal Code, which dates back to 1860, to the National Disaster Management Act that dates to 2005, a combination of all of these laws have now made a concerted effort towards combating COVID 19 a possibility. The next video will talk about welfare and governance measures. We will talk about the role of the ministries. We'll talk about the funds. We will talk about what does ICMR do, what does CSIR do to essentially combat coronavirus. Until then, stay tuned. If you do like the video, please press the like button. Please subscribe to the channel. It really, really means a lot. And your comments are always most welcome in the box below. Thank you so much. Stay safe.